Okay, hi again. We're back. Attorney Steve Vondran here. We are talking in Arizona litigation. We're talking Rule 26.1 disclosures. What is that? What does that mean? This is general legal information for you by Attorney Steve. Basically, a disclosure document is nothing fancy. It's a, you can see it's a short document that basically has about 9 requirements in Arizona, things that you have to disclose once you're involved in a lawsuit. Now, what's that mean? So one party is suing the other. The party that's suing is called the plaintiff. The party that's being sued is called the defendant. And in Arizona, and similar to the federal rules of civil procedure, in federal court cases, you have a disclosure document that you need to get out. Usually it's within 40 days of the answer being filed. So if you sue somebody, the defendant answers within 40 days, that triggers the disclosure requirement. The parties need to disclose, do one of these little disclosure documents I'm talking about here, and disclose certain things to the other side. Now, why would this be? Well, the main reason for the rule is to put your cards on the table and show the other party what your claims are, what the factual basis of your claims are, what the legal basis of your claims are, who the witnesses are going to be, who you think they're going to be. Do you have an expert? Who's going to be your expert? So I can weigh in and analyze your case. And the idea, I think, is to promote settlement and full disclosure of all the relevant facts that you're aware of, so that the case can proceed a little bit quicker. Is another idea why I think it's there. So, but your disclosure document, it's a requirement, and it's a document that you're going to want to take some time with and make sure that you have a nice, good disclosure statement. You do verify these, so they are under penalty of perjury at the end of the day. So you want to make sure that the contents that you're putting in here and that our clients are putting in there are true and accurate, and that you're doing a good disclosure. You're researching the things that you have and presenting those in your disclosure document. So let's talk about some of the requirements, things that you're going to want in your disclosure document. First of all is the factual basis for your claims and defenses. If you're a defendant, you're going to want your defenses. Typically, when you file an answer, you're also going to file your affirmative defenses, and we have videos on answer, what an answer is and what affirmative defenses are. So make sure you check out those videos. But you're going to want to basically give the factual basis. What are the facts? Why are you claiming damage? Why are you claiming the defendant did this to you? Why are you claiming you have a right to countersue? Why are you making certain defenses like contributory negligence? He was negligent, she was negligent. Why are you making those defenses? So you lay down your facts, a good statement of your facts, okay? Then number 2, the second thing you're going to be disclosing in your Rule 26 Arizona disclosure document is the legal theory upon which you base your claims or your defenses. Your legal theory, what is the law that supports you? If you have case law that you're relying on, get that case law in there and let the other party know the legal basis for why you have claims and defenses, okay? So that one, again, you want to take some time with. You want to know what your grounds are, how you're going to prevail. And, they may very well look at your facts and your law, and they may very well say, wow, I didn't know that. Geez, maybe we better settle this thing. Maybe we are in the wrong here. Maybe we don't want to litigate this case on out. So that's why you want to take the time and really cite a good statement of facts and the law. Number 3, you're going to disclose in your Rule 26 Arizona Rules of Civil Procedure disclosure statement, you're going to disclose who you think your witnesses are going to be. Okay, so list them out, their names, address, phone number, fax, email, their contact information. Let the other side know who your potential witnesses are. They may want to contact them. They may want to take their deposition. So look into that, take a good look, and disclose your witnesses. Don't forget, you also want to disclose what their expected testimony is. So lay that out. You don't have to be super elaborate, but lay out, disclose to them what you expect your witnesses to testify to. Okay, after that, that's number 3. Number 4 is any other persons that you believe would have pertinent knowledge about the case. Anyone with pertinent knowledge about the case. Again, name, phone number, contact. Lay it out. Let them know other people that may have some facts that could be useful to the case. You've got to disclose it. Okay, it's to avoid the trial by ambush. So pertinent people with pertinent information, even if you don't expect to call them as a witness. Okay, that's 4. Number 5. Names and addresses of all person who have given witness statements pertaining to your case. Witness statements pertaining to your case. Things that people have documented statements, okay? That's number 5. And state where those statements reside. Who are the custodian of the statement? Who has it? Does the police department have it? Does the insurance company have it? Who has the statement? Okay, so that's number 5 in your Arizona Rule 26.1 disclosure statement. Number 6, names and experts of all expert witnesses. All expert witnesses that you plan to call at the trial. Okay, that's easy. You're gonna have let's say you have a real estate case. You're gonna have somebody you're alleging breach of the duty of due care, fiduciary duties. You're gonna want an expert in there to set your standard of care, to show the jury or the judge, if you're going to have a judge trial, to show them the standard of care and then explain in the expert's opinion why that was breached, why that standard was not met. Okay, so disclose names, addresses, contact of all your expert witnesses and a synopsis of what you believe they're going to testify to. Okay, that's full disclosure. That's Arizona Rule 26.1. That's what you want to do. Okay. Number 7, computation of damages. You're going to want to show, this is what I believe my damages are. If you're a plaintiff suing, these are my damages. If you're the counterclaimant, you're suing back, the statement of your damages. How did you arrive at your figure? Lay it out, break it down, itemize it, give the damage statement so the other party can look and say, yeah, that's a damage you can recover. That's overstated. That's a damage you can't recover. You're wasting your time, and so that you can basically flame the fires of settlement and try to have a rational discussion about what your real damages are. The real damages the law will recognize. Okay, so that's why you're disclosing. You're putting this down so you have a chance to meet and confer with the opposing counsel or the opposing party and say, what do you mean you can collect emotional damages on this? You can't get emotional damages for that, and you couldn't prove it if you did have it. So a computation of your damages and the names, addresses, and telephone numbers of all damage witnesses, anybody that's going to testify in regard to your damages. So that's number 7 in your Arizona Rules of Civil Procedure, Rule 26.1, disclosures. Okay, so lay that out. We only got 2 left. If you made it this far, you're doing really well, and you are potentially a litigation warrior. Well done. Number 8, you're going to want to explain pertinent documents, documents essential to your case. Identify your documents, describe them what they are, the date of your documents. You're probably going to want to bait stamp your documents so that you can refer to a bait stamping of your documents. Okay, so disclose the existence, location, and general description of any documents or tangible evidence. It could be a tape recording. Okay, tangible evidence, disclosing your USET trial and any relevant insurance agreements. So lay out your documents, okay? You know the documents that you're going to be using at trial. Lay them out, disclose them. Arizona Rule 26.1, number 8. Finally, you have a list of all documents or categories of documents known by the disclosing party to exist, whether or not in that party's possession, that may be relevant to the subject matter of the action or which appear reasonably calculated to lead to the discovery of admissible evidence, blah, 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 blah. In other words, if you have any other relevant documents, here's a good place to disclose them, make them available for inspection, so forth and so on. So that's really what you're trying to do in the disclosure document. You're really laying out your case. As I like to say, you're flipping your cards and you're saying, here's what I have. Okay, in some other states, like California, where I litigate, you don't have this early disclosure requirement. That's not something you have to do. Federal court, you do have it. So that's what it is. You verify it at the end. Verification is basically saying, I have reviewed this under